Stanford University.
This presentation is delivered by the Stanford Center for Professional Development.
All right, we're going to get started. A couple things I want to mention before we actually get the lecture topic today. This class is offered both kind of on campus and off campus. The only ones who are actually able to take the off campus ones, though, are actually SCPD students. So if you're an on campus student, please be here. This is how you're actually going to get, you'll be called on and asked to be participation. Two warnings. The good news is that I'm an actual patent attorney, and I actually represent quite a few clients, about 100 different startup clients. That's the great news. The bad news is that takes up about 60, 70, sometimes 80 hours of my week. And so this is kind of shoehorned into that week. I'm not here on campus. I show up a few minutes before class, and I leave a few minutes after class. And so this is not my life as a full-time professor here. Fortunately, I've taught this class 15 times, and so I kind of know what I'm doing at this point, and so I could actually do this thing pretty quickly and kind of jump right in. But what this does is kind of limits our interaction outside of class. I will have I will have office hours, but that's going to be somewhat limited. It's going to be in the future. I'll post it. It'll most likely be during lunch from like 12 to 1 right before this class. And I'll most likely be outside in kind of the Tresidder Student Union type of area. But I'll post that on the syllabus and send it to you guys. The second thing that I need to warn you guys of about this class is that it's a law school class, effectively. And there's going to be subjective grading. This isn't an engineering class where it's going to have an actual answer of like square root of this number. The good news is that you guys don't have problem sets. You don't have to worry about problem sets. And there's not going to be a final exam. But the bad news is that this thing is subjective. And I'm going to give you guys the best like opportunity and ability ahead of time to know how I'm going to grade. But in the end, this thing is a subjective grading between the 82 students that are in the class and my one official TA for the class and my limited time. Like you're not going to get a ton of feedback and a ton of comments on those otherwise subjective reading assignments. Any questions on either of those two warnings or anything else that we need to handle kind of procedurally before we start class today? I will check to see if they're going to cut the lawn every single day during our class, right outside this door. That's one thing I'll try to do. All right. Today is actually a fairly light lecture. We'll talk about the types of patent protection, the steps along the patent process, the sections of a utility patent, and then at the end we'll actually do a little bit of interaction with the uspto.gov website. Jumping right into the Socratic method. Layla Barapur? Layla. What are the three types of a patent, and what do they cover? Yep. So utility, design, and plant. What do each of those cover? Great.
Design is basically the aesthetic feature.
Okay.
And plant is the asexual plants that
Awesome. That right there was a great answer. These are the types of questions that I'm going to ask. She proved without a doubt that she read it, and that was really all we need to do. Thank you. Utility patents from this slide forward. Every single time I say patents, we're going to be talking about utility patents. 20 years from the earliest filing date. This is a change in the law. The law changed somewhere around 7-8 years ago, where it used to be 17 years from filing date. From issue date. Now it's 20 from the earliest priority date. Design patents. In Europe, these are called industrial designs. Now, 14 years after the issue date, ornamental or aesthetic features, not the utility features. I had a client come to me earlier this week, like, hey, can we just file a design on this particular component right here? And it's pretty clear that that particular component was doing a function. It was actually a bumper to allow these things to not fall off. And it was like, well, the patent office isn't going to allow us to actually design patent that unless we just want that look of it. We can't cover the functionality of something, of a component, through a design patent. A plant patent, this is definitely the last time we'll be talking about this. Asexually reproduced plants, 20 years from the earliest filing date. And as I mentioned last time, I think I've seen one in my entire career. Jacob Beatty? Jacob. And what are the different steps in the patent process?
So you can see that preliminary patent to after up to 1 year after when you're there's the filing where you submit your claim or submit your claim, and then after that the prosecution where the patent office will talk about your or publishing the prosecution. So publishing when they publish it to the public, and that doesn't mean that you actually have a written patent. That means people can look at it. And then the prosecution is when you, the patent office will tell you whether or not they accepted it, and if they don't accept it, you have the right to appeal that. And then if new claims are adjusted, as long as you're not submitting new claims or submitting new claims that were covered originally. And then afterwards, a few of those back and forth, if you don't get it, they'll either accept it, or they won't accept it, or they'll accept it. Finally, ready to patent.
Awesome. Nice work. That first filing that you mentioned, you call it a preliminary. It's actually called a provisional patent application. And that's something that we'll talk later on in the quarter about. Provisional applications are really there just to kind of stake your spot, kind of save your spot in line. And if you file a full patent application within a year of that provisional application, depending on whether or not that provisional has some great teaching and explanation of what you're trying to cover in that full application might be treated as if it was actually filed on that date of your provisional. So there's some strategies there on how you actually can file early with a provisional to get that earlier date. We'll talk definitely much more about that later on. The publication happens at 18 months. This is automatic. You can stop it from happening. You could request the patent office, please don't publish. But if you do that and you happen to pursue any foreign patent applications, then your US patent is now void. And so to avoid that tragic scenario, we never request any non-publication of the patent application. So it's always going to publish at that 18-month mark. That 18 months is 18 months after that earliest filing that you had. So if you filed a provisional application and then 12 months later filed a full application, you'll have that publication 6 months after that. Published applications look almost identical to issued patents. I've actually slid plenty of published applications across the table, and opposing counsel, companies that were looking to invest, other folks that should know better actually thought that those were issued patents. And I allowed them to think that for a little while until later on, the deal progressed to the point that it would have been too embarrassing for them to actually correct that. But these things look an awful lot alike. And oftentimes when people look at something, and you'll be making the same mistake, you'll be looking at a published application saying, oh, I can't believe they got a patent on this. The media does this all the time. Almost every single blog that talks about, I can't believe this thing was patented, it was a published application, not an issued patent. Yes?
If you asked for your application not to be published, but then you go and apply for a foreign patent, it voids the US?
It voids the U.S. patent. That's just the way the rule is structured, as like a very strong incentive not to ask for non-publication. And so for the most, correct. So most people do not actually go down that route of requesting non-publication. In fact, it was such a little quirk that I was debating whether or not to mention it. But you can actually do that. At some point, the Patent Office provides an office action. That office action has a bunch of rejections. This is the way it almost always happens. In fact, if you get in that first office action and the Patent Office says, hey, all your claims are allowed, then you probably messed up. You probably didn't ask for enough. You probably asked for something that was too narrow. It's kind of like if you're going to sell a car, a used car, and someone comes to you and says, well, you know, how much do you want for it? And they're like, well, how much are you going to sell it for? And I'm like, well, you could sell, I'll sell it to you for $6,000. And that person says, great. And they whip out their checkbook. And you're like, I probably should have asked for $7 or $8 or $9,000. I didn't ask for enough. And that's exactly what goes on with the Patent Office. A lot of times people love to talk about, or brag, we got our patents allowed in the first office action. And that's actually not typically a good thing. There are some super crazy pioneering inventions that maybe there's just nothing else there. But even those, they could have been written a little bit broader. And that's actually that negotiation that you have back and forth with the Patent Office. I've experienced recently an increased number of office actions. The benefit, though, or the good side, is that the pendency, or how long it takes to get that first office action, is starting to reduce or to decrease. It used to be somewhere on the order of 4 or 5 years before we would get that first office action. Now we get it somewhere on the order of 2 or 3. But when that 4 or 5 years would go by and we would get an office action, it would be very comprehensive. It would have a great search behind it. And when we would argue and amend, we would go back to the Patent Office, it would be it. It would probably just go back and forth maybe twice, sometimes 3 times. Now the Patent Office is giving that first office action much, much faster, which is great. But they're doing a pretty lousy job, in my opinion. So when we would go back and say, well, look, this piece of prior art isn't anywhere close, then they go and they do another search. And then we argue that, and then they go and do another search. And so I'm finding that we're now seeing somewhere on the order of 4 or 5 office actions. I have a couple of patent applications that are on their 7th or 8th office action. And this is pretty expensive. My firm charges $5,000 every single time we respond to an office action. And so you can imagine if it's 15 to start off, and now you're adding another 35 or 40 grand later on, that this is something that starts to get incredibly expensive relative to the overall cost of that patent application. There's nothing that I'm seeing in the Patent Office to actually get it back down to 2 or 3. In fact, some of the numbers that they're using on their dashboard are actually fairly deceiving. They'll talk about, there's an average of 1.5 office actions, for every case. But what they're doing is that second office action is considered a final. It's not really a final. If you pay the Patent Office a little bit of money, they'll remove that finality and they'll look at it again. And so when you get to that 8th office action, you've probably overcome 4 final office actions. But they're treating every single one of those as kind of like a singular unit, a prosecution, that we gave you a first office action and then you had a final. On average, that was 2. And then you overcame it, and then you had your 3rd office action, and then you had a final. On average, that was 2. And so they're adding up 2 for all of those instead of adding up 8. They're trying to change that and be a little bit more open, but I've had a couple clients call me out on this, why am I expecting 4 or 5 office actions when I'm looking at that dashboard and they're saying it's 1.5 or 2. I'm like, well, that's not really what's going on. because they're counting that final office action as some kind of a disposition of that. And now they're saying that when you file that request for continuation or request for continued examination, that they're opening up a new file, but you're really not. It's the same exact serial number, it's the same exact patent application. So I don't think that they're necessarily being open and honest about that particular issue. With search and examination, so you go back and forth a couple of times, and then as was explained earlier by Jacob, that you're either going to get to the point where you appeal, or it's going to be abandoned, or it's finally rejected, and you've gone as far as you can with this particular examiner, and maybe you appeal that, maybe you abandon that, and the other path, of course, is that it was allowed. And if it's allowed, that's almost the last step. The last step is go ahead and pay the issue fee. And then when you pay the issue fee, it issues probably a month or two after that. I had a client the other day ask, well, notice of allowance, can we actually celebrate at this exact point? It's like, well, we can, as long as we pay. There's nothing else that's going to derail this thing. We got allowance of it, but it's not the same thing as an issuance. We don't have that patent number yet. We don't have any patent rights yet. We still have to pay the issue fee and get the patent office to actually turn this through the patent office and issue the patent. Yes, I'll take a question.
You said that you have no patent rights yet, but aren't you protected at least somewhat by the application since it's been published at this point?
So the application is kind of potential rights. You know, that you have, these things are going to potentially issue at some point. And then once they issue, you have this kind of retroactive rights back to publication. But there's a lot of caveats in that, and sometimes it requires notice, and it requires that the claims that were in your published application actually look very substantially similar to the claims you ended up getting. And so you don't always have rights retroactively. And so you really don't have rights until it issues. And when it issues, you might be able to go back in time. I'll take another question.
Have you ever heard of a situation where someone is filing a patent application and then it gets rejected, and then someone else, because it's published, sees that and then copies whatever it is that they specified that they were going to do?
So I had a question similar to this that just came up during lunch today. And the patent office now sees that published application, that first one. And so when they know of that, that published application, they're going to reject that second one. Because of the first one was already there. And there's another aspect that kind of prevents this thing from happening, the scenario that you're describing, is that every inventor needs to file a declaration. And in that declaration, it's, I am the inventor and I did not derive this from someone else. And that's a federal offense to actually lie on that particular federal statement. And so most people wouldn't do that. And so the concept of stealing someone else's idea after they see this published, I don't think that actually happens, not even in other countries. And so you wouldn't find that US publication, and then turn around and run to China and file it there. Because the Chinese patent office will look to see what all the patent documents are out there, including that published application. They'll find that, and they're not going to allow that to go through the Chinese patent office either. And so this is actually why we publish applications, is to get that knowledge out there sooner. Yes?
Can you file for multiple jurisdictions at the same time?
Yeah, we'll talk about how you would do that, but effectively at either the beginning point or later on after you filed a provisional, that 12-month point, or even 18 months after that, if you filed what's called a PCT application, you could file in several different countries, on the order of about 200 different countries. Any other questions at this point? Yes?
I didn't get this international part of the patent. So if you have a patent in the US and no one can issue same patent in Europe, so what's the point for you to issuing another patent in Europe?
So this kind of goes down to the basic fundamental misunderstanding about patent law. And so you might be able to prevent others from patenting in Europe, but that doesn't stop them from actually making it.
You can issue the patent, And they
But not in Europe. And so you either protected it in Europe or you did not.
You can issue it after they make it. They make a product.
No, so the foreign patent applications and every single patent application has to be filed within a certain period. And so in Europe and most countries outside of the United States, you have to file that patent application before any type of sale or public disclosure. And so your own public disclosure in the United States would actually prevent you from filing a patent application later on. And so you have to make that decision early. And so someone else might be able to actually make it in Europe because your US patent isn't going to prevent that from happening. But you wouldn't be able to prevent them from making it.
Patents in all countries if you are going to do this.
Yeah, sure. There's 216 countries. It's somewhere on the order of about 20 to 40 grand per country. And sometimes a product might have a dozen, maybe 100 different inventions in it. And so we could do the math. I'd be happy to do that work for you. There's a whole class dedicated to that. That's actually lecture 9 of where do we file and when do we file. It's a great question. It's something beyond just this particular lecture. Yes?
So all published professional applications constitute prior art.
So-
After that, no matter what.
So provisionals don't publish. So a patent application.
All published patent applications constitute prior art, no matter.
Yes,
whether
it's
they got
just like anything else in terms of a white paper that happens to be on the web. It's like a PhD dissertation that's indexed and available. It's an article that shows up in Science. You know, like it's effectively just an article, and that's what they're doing. They're making that now prior art to other patent applications. Yes.
Did you just say that provisionals don't get published?
They're made publicly available later on. And so we could actually try to find them later on in the class. They don't publish in the sense the same way that published applications publish, but you could dig through the file history and actually find it. That's only if they're used. And so if you don't end up filing a full patent application within those 12 months, you effectively abandon that provisional. That's not publicly accessible. It's not published. It's not indexed. You can't find it. So it's a great way of being able to say, all right, I don't know what I want to do with this yet. I don't know if I want to open source this or trade secret or file a patent. Filing a provisional application kind of gives you that option. One last question in the back.
I was wondering if you could explain a little bit about how the sale of a product validates or invalidates like a provisional patent, like when that can occur with the
So there's an
timing.
entire lecture on that, probably 2 lectures.
Okay.
It's a fairly complicated question, actually. I'll definitely get back to that. Did you have one question?
It was regarding the international versus US patents. So if you have a US patent and you manufacture in Europe, you can't sell that in the US because
So if you hold a U.S. patent, someone else can manufacture and sell and use in Europe, but they can't import it into the United States. The last process here was the grant or issuance, and that, as I mentioned, takes about a month and a half. Michael Chen? Michael, what are the 3 major functions of a utility patent? And by functions, I mean the actual, like what is the utility patent as a document? How does it function? What does it do?
As a document, it certifies the, it introduces the patent owners and what they're about, what their patent, and declares I'm the inventor of this. Also, it describes what the patent is, and if it meets, and in this, it meets the enablement requirements. And they also have to describe the scope and protection of the coverage, and this is where infringement cases will come into play.
Awesome. Thank you, Mike. The 3 functions of a utility patent. Let's provide some details about the inventor and the owner, the filing date, the priority date, the title and abstract, representative drawing. All of these things actually appear right there on the front page. What were some of the patents that the examiner looked at and cited and thought about during the examination process? It's right there on the front page. One of the things to keep in mind is that that owner that's on the front page, if there is one, and that's called the assignee, just a fancy legal word for owner. That assignee is printed once at the time of issuance. That's not updated. So in today's society, we would look at a document and we would assume that this was updated at some kind of period, and those are not at all. We'll find out later on how to actually figure out who the current owner is. A second major function of the patent document is to actually describe it in enough detail that someone skilled in the art could actually make it without undue experimentation. What does undue experimentation mean? It's just a big legal phrase that just means, look, it wasn't too hard to actually make this from what you have. You don't have to have a CAD file in there. You don't have to describe every single thing. But someone that's skilled in the art, someone that you would actually put on this particular project, they would be able to figure out how to make this thing without too much extra effort. It's really important to understand and distinguish this particular function and this particular section with the next section. So this section we call the specification. The next section is really called the claims. And the claims define what the actual legal protection of that particular patent is going to afford. These two things are actually two completely different documents that happen to be stapled together. One you could think of as like a white paper, or a blueprint, or a recipe, or instruction manual, something along those lines, very technical. It has a lot of details, and it has to have a lot of details, because it needs to teach someone how to make and use this thing. The other document is a legal document. That's the document that the Supreme Court have said, this is the hardest document to write, legal document to write, period. Or the claims in a patent application. That claims, each one of those claims can only be one sentence long. Start with a capital letter and they end with a period. I actually had an examiner reject one of my claims because I capitalized another word inside that claim, and they were saying you could only have in a sentence, in an English sentence, you could only have one word with a capital letter, and that's the very first one. My hunch is that English wasn't actually this examiner's first language, but they were trying to apply this particular rule, which was, look, it's a sentence, it's one sentence. In that one sentence, we're trying to describe every single thing to make this thing different about what's been done in the past, and yet in a broad enough way to capture everything that a competitor might try to do to design around it. That's a very, very different document than the detailed description, which is trying to teach someone how to make and use it. And I'm stressing this particular point because this is going to come up over and over again. When we think about infringement and when we think about patentability, there are two different documents in a patent. One's a very engineering document and one's a very legal document. And you can't take a look at the engineering document and say whether or not it's broad or whether or not it's narrow. You can only do that from the legal document. And you can't take a look at the legal document and figure out, well, yeah, I understand how to make this thing. Because honestly, you're not going to be able to figure out just about anything from reading the legal document. Is there a question?
Yeah, so when you read patents, the claims are one sentence, and they're sometimes incredibly hard to understand, right? Is there any sort of notion as to are they going to change that? Is there just a historical innovation to have one sentence, or because you could make it so much easier to read for people if you just allowed for more sentences?
I don't see it changing anytime soon.
It's just historically.
Yeah, and it's really so that you tie it all together in terms of this is exactly what I'm trying to protect right here. And it will come a little bit more clear later on of that we need to have some structure in how we present that claim. The very, very early patents, they would actually talk about the inventions described in the specification. They wouldn't actually have claims, the very first ones. But it turns out that that was kind of vague. That like, well, which one? Which invention that you described? And does it cover this or does it not cover that? And so we needed something, and I'm going to come back to this concept of abstraction layers. So where we needed to say, all right, well, here's this document that's stretched on over 5 pages, but tell me exactly what you're trying to cover. And we needed that, and hence the kind of the claim language is born. It doesn't have to be completely illegible, or ununderstandable. In fact, we write claims at my law firm that people typically could understand. But even then, they're still it's definitely not regular English prose. There's a lot of limitations on how we can present something. And that's why claim writing is just outside of the scope of this class. And there's effectively an entire class that I teach here on how to write a claim. Yes?
How does the patent office and general district, how do they determine whether the specifications are specific enough, especially for highly technical documents?
Oftentimes they don't. And so this is something where it comes into question in litigation later on. That you're trying to claim this right here. It typically comes into play when you're trying to claim something a little bit broader or reaching a little bit with your claims. And then coming back and the patent office says, well, you didn't actually even describe where you're trying to go with those claims. And so the description, you're trying to claim something really broad when you're actually talked about something much more narrow over here. And that either comes out in some of the office actions, but most likely it comes out later on in litigation. Again, we could ignore the front page as a section, but I really want you to be thinking about a patent document as these two totally different documents with completely different purposes that happen to be stapled together. And we're going to actually look at one. So what we have here, it's going to be a little bit difficult to see, but I'll blow it up, certain sections of it up, is Dean Kamen's, one of Dean Kamen's patents on the Segway. This is the front page. You'll see Dean Kamen's name right up there in the upper left-hand corner of that patent. Kamen et al. That et al. Is simply just saying, hey, there's a bunch more inventors other than just Dean on this one. That particular lead inventor or the named inventor doesn't actually have any legal significance. This patent will often be considered the Kamen patent, but the fact that he was the name that gets listed on top of the patent, again, doesn't have any legal significance whatsoever. Some of our clients say, well, how do we choose who's the lead inventor or the named inventor? And I'm like, well, if it's not obvious to you guys who that lead inventor is, we could flip a coin, we could go alphabetical, we could do something random. It honestly just doesn't matter. Sometimes this is kind of given in some companies. You might have $1,000 for every single time you're named on a patent, and maybe $2,000 if you're the lead inventor, and now there's a lot of great infighting in companies over that particular recognition. And honestly, it just doesn't matter. The patent number's in the upper right. There's a B2 behind this. I don't have any idea what that means. In Europe, they often republish patents. And they would actually have maybe B3 or B4. In the United States, we don't do that, or at least don't do that yet. And so maybe they're hopefully anticipating some time where we do that in the future. But as of right now, that B2 doesn't mean anything. It's really just that 7-digit number. This one starts with a 6. We're actually in the 8 million series right now. The issue date. This was issued November 25th, 2003. It was filed back in May 22nd, 2001. And so they'll have 20 years from that particular date while this thing is still enforceable as a patent before it expires. One little question that I often get asked is, well, can you reapply? And in the end, when this thing expires, can you reapply? What would be an answer of why, could you reapply? Why not? Why not? Why can't you reapply for this?
It's prior art.
It's something is prior art. this thing published. Even if it wasn't a published application, it's still issued, and this thing is now out there. So even if you never even made the segue, which would be horrible, even if you never made the segue, then like it would still, this document right here would be prior art from actually reapplying later on. And so we are assured that anyone can make a segue May 22nd, 2021. The title of this one is Personal Mobility Vehicles and Methods. No legal significance of that whatsoever. The owner at issuance was Deka Products Limited Partnership. Deka, probably the first two letters of Dean Kamen's first and last name. The filing date, the priority date, abstract, and drawings. The abstract on the front page and the drawings, again, don't have any legal significance. This is really just to help people when they're searching to try to find other relevant patents. Back in the day when you would actually search things manually, which is actually how I started doing patent searches. We would pull a stack off of this, it was called a shoe, in the patent office, and you'd like put it up against your hip, and then you would flip through the patents really quickly. They were stapled on the bottom, so you could actually flip through the pages super fast. And they would have the patent drawing, and you would have the abstract right there on the front page to be able to figure out whether or not this thing was relevant. Honestly, this doesn't really have that much impact in today's society when it's all electronic. These are some of the key things that I pointed out earlier with the patent numbers and first name inventor, the assignee, the owner, and the filing date. Then we get into the specification. That's page right after that front page. And it's usually a series of drawings. There's some inventions that don't have drawings, typically in the chemical fields. But most inventions have drawings. Even software ones have some kind of flowchart. This one is figure 1. She looks like she's having fun. And so this is part of the engineering document, the specification, teaching someone how to make and use this. That guy's definitely a little too old for that device. Figure 3, we have a circuit document, or circuit drawing, and it's actually not a circuit, it's just more like a flowchart. And figure 11, just a different embodiment, a different way of doing the segue. Maybe it would have sold better in that version. And then right after the drawings is a bunch of text. And that text, again, we could see the title here. And there's a background section and a summary section and a brief description of the drawings. It's actually not required to have a background section. And as academics, I am in a university setting, so you could call yourself academics. As an academic, you're most likely, when you prepare a paper, typically any kind of paper that you're preparing, you're going to talk about what's been done in the past. Typically, like even a PhD thesis, you might spend a significant period, a significant portion of that document talking about what's been done in the past. Maybe it's 80% what's been done in the past, and now it's 20% of the things that you're doing new. In a patent document, it should be exactly flipped. She should be talking about stuff in the past very, very briefly, and in some situations, not even at all. The patent office is going to find their own stuff. They're going to do their own search. It doesn't really matter. Anything that you talk about in the background is actually just an admission, and it's most likely going to be used against you and not for you. So I'm telling you this now because you're going to be preparing a provisional patent application in this class as an assignment. And you're going to want to start with a background. You're going to run out of time before you actually get to the most important part, which is to teach someone how to make and use your invention. Trust me, I've graded enough papers on this exact topic that I know that this is what a good portion of you are going to do, or at least go down this particular path. Let's not start with a background. You don't actually need a background. You might want to do that to help you understand this and be able to help you frame your particular mind around what is patentable about this. Great. That's done in a patentability search. Keep that as a different document. We're going to. That's actually assignment number 1. And at the end of assignment number 1, we're going to have some kind of statement that says, this is what we think is patentable. And then that statement kind of looks like a claim. And really, that's all you need to do. is to be able to kind of start from there and then describe how to actually make and build this thing and use it. You don't need the background section. I'll just say that one more time. You don't need that background section. It's not required. I have it in nearly all the patent applications that I write now. There was a section about 6 or 7 years that I didn't write background sections at all. But my clients kept on saying, well, where is the background section? And I was tired of explaining to them that it wasn't actually required. So we have very, very thin ones now. It's about a paragraph long. We never talk about what's actually been done in the past. I usually just present the problem. Yes?
And then it's presented in the background affect the claims later in the document?
Yes. In a negative way. Never in a positive way. Nothing in the prior art allows you to do this or have this advantage. Great. You might be claiming something over here, but you just talked about this advantage, and that advantage now is going to be tacked onto your claims and make them more narrow. There's actually several cases on that exact issue. A summary invention, I don't write summaries. A lot of people do. You can. But the summary section, again, just like the background, is only going to be used against you. It's not going to really help you at all. It's a brief description of the drawings, and this is super simple. And this is just saying, hey, figure 1 shows this, and figure 2 shows that. And then we get into the real stuff, the detailed description of specific embodiments. I don't use that particular phrase, but this is the detailed description. This is the portion where we're now teaching someone how to make and use this. I'll go over this exact hint later on, right before we talk about how to write a provisional application. But the best way to get breadth in the detailed description is to be very specific multiple times and talk about different variations, but to have that specificity. And to be able to say, all right, well, it could be anything, any kind of fastener. No, talk about 3 or 4 different kinds of fasteners. And now you've just talked about and you've given a nice generic umbrella around that. So many inventors want to be vague in the detailed description. And they equate vague with being broad protection. But we need to think about these things as 2 separate documents. And in the detailed description, we're very specific. We get some breadth by the fact that we talk about different variations, but with a lot of details. In the claims, we're going to be broad, and we're going to go after the breadth that you want. But that's actually where we want the breadth, is in the claims, and yet we need specificity in the detailed description. And so when you're reviewing a patent application written by one of your patent attorneys, and you're reviewing the detailed description, it needs to be detailed. The first hint is the actual section of it, the title of the section, the detailed description. That's the detailed description, that's the specification, that's the engineering document. There's a whole nother document. This is actually, I still need to change this. This just so happens that the claims start on its own page. You can see it right up there. This is just completely coincidence. Typically the claims, they're just right after the detailed description. That's why these 2 sections kind of get very confused. You see the drawings, and then you see the text, so the detailed description, then you see the claims, and they're just running right after each other. But the claims are a completely different section. It's a legal section. I'm going to read this one for you, for your entertainment. It's a device for carrying a user with a desired unassisted motion over a surface. The device comprising a platform which supports a payload, including the user. A ground contacting module coupled to the platform, the ground contacting module capable of balanced operation on only 2 laterally disposed and separately rotatable primary ground contacting members. What are those things?
Wheels.
But what else might they be? Chains or tracks, right? And so the patent attorney couldn't think of something that was generic to cover wheels and tracks. And so they came up with this great phrase, ground contacting module. 2 laterally disposed and separately rotatable ground contacting members. That was the phrase that was used to try to generically describe wheels and tracks. A track really isn't a wheel. They didn't want to not include tracks, and so that's what they used. The platform and the ground contacting module being components of an assembly. In a motorized drive arrangement mounted to the assembly, the motorized drive arrangement causing, when powered, motion of the assembly in such a manner as to be propelled in response to leaning of the device, and such that leaning of the device is not canceled while the device is in motion. Got it? Do you know how to make it? No. This portion doesn't teach someone how to make and use it. Do we now know if something is patentable in light of this? Probably not, because we don't really know what this thing is. And so when we're trying to compare our invention to figure out whether or not it's patentable, we're not going to compare it to claims. That would be silly. We don't know what this thing is that I just described. Do we know if we infringe? Yeah. We could go through our device and say, well, does it have a platform? Does it have a ground contacting module? Does it have these ground contacting members? Does it have a motorized drive arrangement? And does it have, in response to leaning of the device, such that leaning of the device is not canceled while the device is in motion? Do we have that feature? We know whether or not we have these things. This is what a claim does. It allows you to determine whether or not you infringe. That's pretty much the only thing that the claim does. Yes?
So are you protecting against each of these claims individually, or a device that has all of these claims?
So one of the unfortunate things is that it uses the word comprising. And comprising kind of sounds like a word that we might use, but it's not really. This comprising is an open-ended including. And so it says that we're only protecting a device that has all of these things, but it might also include other things. But if a device has these things, then it infringes this particular claim. Claim 2 is a device in accordance with Claim 1, further comprising a differential controller actuatable to cause each of the at least two ground contacting members to be differentially driven so as to cause specified turning motion of the device about a device fixed vertical axis. This just allows the two-wheeled thing to actually turn. What was being protected in Claim 2? Just said.
An addition onto the Claim 1, like this.
That's actually a very key fact. Sometimes when people look at patents, they're going to take a look at Claim 2 and say, well, this is just two wheels that rotate and, with some kind of different rotation to allow the thing to turn. Like, that's been done plenty of times before. And they might take a look at that Claim 2 and say, well, that's ridiculous. This whole patent's junk. They'd be jumping probably to the wrong conclusion. Claim 2 is shorthand for everything I just said in Claim 1 and this other thing. We have any electrical engineers in the audience? So what's an AND gate?
The both inputs are both one.
So in Claim 2, this happens to be a dependent claim, and so we're just doing an AND gate between Claim 1 and all this other language. And so later on, when you are trying to do an infringement analysis, it's this element A and element B and element C and the stuff that we're talking about in Claim 2. It's not just one of these things. They're not trying to patent the wheels. They're not trying to patent the wheels turning at different rotational angles or velocities to turn. They're patenting everything that was in Claim 1 and the stuff that's in Claim 2. Yes?
be enough to prevent anybody from making or selling either one or two, but they're writing claim two so that somebody else doesn't write a patent preventing them from building with the additional.
Because claim 2 doesn't really teach anything. And the best way to prevent someone from patenting something is to teach it. So why do we have dependent claims? Why couldn't we have just settled with claim 1? Yes?
Patent office say that's too broad.
They might. And so it might be nice to be able to walk into the patent office with more than one claim. I talked about earlier how you might have to go back and forth with the patent office 3 or 4 times. And that's probably with 30 or 40 claims. Could you imagine if you could only go to the patent office with one claim? Can I have this? No. Okay. Can I have this one? No. Okay. How about this one? No. And it would just be, I mean, that would be ridiculous. It'd be awesome for law firms, but it'd be ridiculous for inventors. And so what we do is we say, all right, well, let's give the scope of protection. I want something really broad in claim 1, but if you're not going to give me that, let's go with something a little bit more narrow in claim 2. Claim 3 is dependent on claim 2, so we're even more narrow than that. You're adding something else. Claim 4 is dependent on 1. We're going off in a slightly different direction with this one. Claim 5 is dependent on claim 1. We're going off in a slightly different direction with this. And so we're adding new things, we're adding limitations, we're adding words, we're actually adding narrowness. I don't have a better way of saying that. But we're getting narrower protection when we add words. This is a very, very, very important concept in patent law. The more words that are in a claim, most likely the more narrow the patent is. The fewer words in the claim, most likely the broader the patent it is. But that needs to sink in for a second or two. Because when people talk about a comprehensive patent, we need to get more things in that patent so that we cover them. I hear this all the time. Well, shouldn't we include the stand, and shouldn't we also include the cord? No, because we don't need to. We could be broader than that. Well, we need to be comprehensive and cover all of these other things. Let's actually cover the core, the real technology here. Yes?
I still don't get it. Then when it's issued, why doesn't the patent office say, well, it's only claim 1?
Great question. So we now know why we have dependent claims when we walk to the patent office. But why do we have dependent claims when we actually walk away from the patent office? Why don't we just have one claim? Is the patent going to be examined again? Yes?
If someone ever tries to contest the patent that you have and you have to actually litigate it.
Sure. So maybe this thing goes to litigation. And I'm suing you for $100 million. Are you going to do a better job of searching the prior art than that government agent? There's a little bit more at stake, right? It's not just your government agent's job. It's now $100 million or $1 billion. And you're going to do a really good job of trying to find that piece of prior art that might invalidate claim 1. And so I would want to have a patent that doesn't have just one claim, but actually still has a scope. So that if I actually go try to sue someone and I don't get claim 1, I might still have a backup plan. And this is yet another thing that people get confused about. They might just read claim 1 and say, that's ridiculous, this thing has been done before. This patent should never have issued, this is way too broad, we could just ignore it. I took Jeff's class and he told me that all I have to worry about is the independent claims. And I looked at that claim and it's too broad, I don't have to worry. That's wrong. Claim 1 gets knocked out, then claim 2 is still sitting there. And if claim 1 was too broad, it's possible that the narrowness, the extra words, the extra limitations that claim 2 provided might actually not be found in the prior art. And so claim 2 might still stand. And so this is why we have this range of claims, both when we walk into the patent office and when we walk out. Yes?
These dependent claims, does that mean that if one is invalid, all subsequent dependent claims become invalid?
No, so this is a confusing part. We'll cover this many times, but I'll give you the the quick little preview of what's going on. So if we're taking a look at claim 1 and we say, oh, we don't need to worry. We actually don't have a ground contacting module. We have a hovercraft. So we don't need to worry. Could we infringe claim 2? If 2 depends on claim 1, and we say that we don't infringe claim 1, could we infringe claim 2? My electrical engineers? Could we infringe claim 2? No, it's an AND gate. We just added another limitation. And if we didn't satisfy the beginning, the shorter version, we're certainly not going to satisfy the longer version. We can't infringe claim 2. And so when we're looking at a patent and we're trying to decide whether or not we infringe, all we have to do is look at the independent claims. I'll give you a second to write that down. But if we're looking at a patent and we're looking at independent claim 1, and we say, yeah, we actually do infringe, but there's no way that a court is going to uphold this. That's just way too broad. This patent is junk. We don't need to, we could just ignore it. There's a problem with that logic. And the problem with that logic is that they have another wall. They have plan B. And the plan B is you can knock out claim 1 with a piece of prior art that you know of, but they still have something a little bit more narrow than that. Claim 2. This is kind of the interplay between independent claims and dependent claims. Yes, in the back.
Is it possible that only part of a claim gets knocked out, or is it the entire claim that's invalid?
Great question. And so you either infringe or you invalidate the entire claim. It's that claim is that all of those things together. In this particular situation, the patent attorney used A, B, and C to kind of signal the different elements. I used bullet points. Sometimes examiners don't like bullet points, so they make me remove the bullet points. Sometimes we have 1, 2, and 3. So most of the time, they're just squished together. But you can kind of pull out like what those elements are. But that claim is the combination of those things. And so if you look in there and say, well, that ground contacting module, someone's done that before. This whole claim is junk. That doesn't make sense. Because what they're claiming is the combination of those things. Any other questions on this? We just kind of skipped ahead a little bit, but I think it's a good time to be talking about this because we could, we'll have plenty of opportunities to kind of reinforce this. Yes?
Is it possible to add claims at a later stage after filing your application, or are you required to file a separate application?
So you can amend the claims, you could argue the claims, you could change the claims, but you're locked into how far you could go with those claims based on what you wrote in the detailed description. That's why it's great in the detailed description to have a bunch of different variations, so that later on you can move those claims around a little bit. The medical device industry uses this all the time, because you're filing something, a patent application on a device, but you don't actually know what's going to go through FDA. You might have to change that a couple of times. And so it's great to have a lot of different variations up front so that 5 years from now, when you get through FDA, you could actually change those claims a little bit to actually cover what you're doing. After it issues, you still have some limited opportunities to change the claims, typically to make them more narrow. Yes?
Suppose somebody built a Segway which was almost identical to the device mentioned here, but it had some novel way of turning which meant that it could escape the protection of clause 2. Would that still be infringing?
So if they infringe claim 1, then they infringe the entire patent. We'll talk about this again in the infringement lecture, but you only have to infringe one claim to infringe the entire patent. One last question on this topic.
It's right off of that. I wanted to ask, there's a specific example of this. There's something called the double robot, which is basically an iPad on a Segway.
Very familiar with the double.
Well, there you go. So how does that not infringe claim 1? Does it have to do with that there's a user riding a...
So a platform which supports a payload including the user. We might be able to stop right there. doesn't have a user. And it doesn't have this at the very end, such that leaning of the device is not canceled. Which part did I want? Causing wind-powered motion of the assembly such that a manner to be propelled in response to leaning of the device. There's no user in that particular phrase, but there's a phrase, they mentioned user early on. But the user is actually kind of part of this direct object of a prepositional phrase. Is that really part of that claim or not? I think that's a good question.
And so therefore does claim 2, it doesn't provide a backup to claim 1 in that specific
So if you don't
instance?
infringe claim 1, you can't infringe claim 2 because claim 2 includes all that language of claim 1. And if you've already identified something in claim 1 that you don't have, then you're not going to infringe claim 2 either, because you still don't have that limitation. You're still omitting that. Great. I want to be able to check the status of a patent. It's not particularly easy to navigate the uspto.gov website. And it's not really all that easy to determine the current owner. But we're going to do a little bit of searching to kind of help you guys. We're going to jump into actually interacting with the Patent Office or the website of the Patent Office. So when you go to the website for the Patent Office, there's kind of 2 different portals. There's a public one and a private one. The private one doesn't give me access to everyone, so I have access to the private portal. But that doesn't give me access to other people's patents. It only gives me access to the patent applications that I'm working on. And really the advantage is I now can access patent applications that I'm working on that haven't yet been published. So that's really only the difference between the public pair, which is their portal into looking at patent applications, and the private. It's just that I can look at my clients' patent applications that have not yet been published. I have a client that's working in the CAPTCHA space, and I can't wait till they start working with USPTO, because typically this doesn't work on the first time. I got lucky. This is the issued patents that I worked on recently. The Patent Office is a little bit of a stickler for how you actually type the numbers. If this had a patent or a patent number in front of it, then it's not going to work. And if you have slashes or hyphens, it's not going to work. But it worked. I entered a patent number. And we're now looking at the file of this particular patent application, this issued patent. This is just kind of some of the high-level information that's going on here. We know the examiner that was working on this. We know the filing date, the application number, the publication number of when this thing published, how to identify that publication number. You could probably see me on this particular page of the attorneys and agents that are working on it. This is all of the different documents that are in this particular file. This looks like a lot, but this really isn't that many. Down here on the bottom, the drawings, the abstract, the claims, the specification, these are all the sections of the patent application that I actually filed. I don't know what's going to happen if I actually just click on this. There we go. So when I file claims, that's what it looks like. So in this particular case, we filed 25 claims. The oath, the specification, the abstract. We filed a preliminary amendment, probably changing some of the claims. This is the filing receipt that you get back from the patent office saying that, hey, we've actually received your patent application, and this is the information that you provided us, and this is used to kind of prove to investors and other people that, like, hey, we actually filed a patent application. Somewhere in here, there's probably a rejection. Here we go. The Patent Office has this little funny way of talking about things. And so a non-final rejection is what that first office action is. And so they often kind of talk about something with respect to what it's not. Once we started having provisional patent applications, a full patent application is now called a non-provisional. I think that's pretty ridiculous to talk about patent applications as non-provisionals, and so I don't actually ever use that particular phrase working with my clients. But when you have lawyers talking to other lawyers, that's usually the phrase that they use is, when are you going to file that non-provisional? Let's take a look at that rejection. What can you see from there? Very little. This is the front page of it. This is what kind of peeks out of the envelope if they're going to mail it to you, which they typically do. And then here's a kind of summary section of what's going on. This is the first office action. Claims 1 through 25 are pending. Claims 1 through 25 are rejected. They always have this great way of like making you feel really good about the patent application, especially when you're sending it to your client. Hey, 1 through 25 are, those are rejected. But again, this is actually fairly normal, and you can see this ended up being a great issued patent later on. The drawings are objected to. They must show every feature, and it doesn't show this one feature. You need to send new drawings. The declaration makes no reference to the parent application, and so they're nitpicking a couple things. Great, we need to check and fix those things. There's a 112 rejection here. We'll learn about 112, and this is more about the written description in the patent application, and does it support, is it clear, those types of things. A double patenting rejection, hey, it looks like it's very similar to this other patent application that you filed. And this one's not going to be a very good example, because what we ended up doing was simply just saying, we filed a document that said, you're right, it does look a lot like the other one, but we promised to keep these two things owned by the same company, and therefore we got over that particular rejection, and then all these claims were allowed. And so I picked one that wasn't necessarily great in terms of different examples. Law firm was able to patent a chair, which wasn't easy to do, but I'll show you that one. So this is a different application and issued patent that I'm looking at right now. We filed this patent application back in 2008. Here are some of the drawings that we filed. This is the frame. This is a company called A-Light. This is actually sold in REI. It's more or less a two-legged chair. It's not easy to patent something that has less things, because a four-legged chair does have two legs. It just happens to have more than two legs. And the patent office, it's very difficult to actually patent stuff that isn't there. It's always in this positive recitation of like, hey, we have this, and you've never seen this before, and we combine it with this other thing, you've never seen that before, and you've never seen this combination before. And so some of our most challenging patent applications are when our clients strip away particular features or strip away particular components, and then come back and say, all right, we have a chair that's lightweight, you could pack it, it's a really tiny form factor, it's actually about as small as this cup right here, a venti. It's like a venti package that you could put in your backpack, and but the patent office, we had to argue with the patent office that like, look, like this thing is new because it doesn't have four legs, and that was actually pretty challenging. So these were the drawings that we filed. I'll go into a little bit of the specification. So when we file a patent application, it doesn't have that 2-column type of aspect. It looks more like a regular paper. And this is actually the document that we filed. It has these paragraph numbers to delineate the different paragraphs, and so we could talk with the patent office about what was in paragraph 3 or paragraph 4, and we know exactly which paragraph we're pointing to. And this particular document is 19 pages long, and we talk about the chair. I'll go back, talk about the background. I'll probably be able to read this whole thing. Conventional portable chairs are not truly portable for outdoor use. They cannot accommodate sitting on a hillside or uneven terrain. An example of which is the stadium seat, which consists of 2 flat pads with a hinge in the middle, rigid posts along the outer lateral edges, and adjustable straps that run along the sides of the pad to the corner of the bottom and the top. In a stadium seat, where the user leans back, the sides of the pads and the post are pulled towards the body along with the straps, and generally the heavier the user is, the more uncomfortable the stadium seat is. Further, the user cannot use the chair to sit comfortably on a hillside or uneven terrain. Thus, there is a need in the chair field to create a new and useful portable and comfortable chair for uneven terrain. This invention provides such new and useful portable chair. That's a very typical background section that we write in my firm. It kind of gives a little bit of background of like, hey, what's going on? It talks a little bit about the prior art. We had to talk about chairs a little bit here. It is a chair. Chairs have been around for a while. And so inventing in this space is a little bit more challenging. And so that's kind of the background that we had. We talk in the detailed description about all the different, the frame. And then over here, we talk about the joints, the sling, a couple different variations, optional elements that could be added to it. And at the very end, it's not going to be in this document because it's just a specification. And in the end of our package that we send to the patent office, we have the claims. What we're going after here was a portable chair that supports a sling. The portable chair frame comprising a first pair of bars, each collapsible having a first end and a second end, a second pair of bars, each collapsible bar having a first end and second end, wherein the first ends of the bars could be coupled to the first ends of the second bars, and then these have a frame, and then that includes a joint. So I'm effectively going after the frame. And we did that because we didn't actually think that the competitor would always sell the sling, and that you might be able to sell this thing without the sling, or you sell these two things separately. And so we don't want to include the sling in this particular claim, because that might actually not be what the competitor has for sale. And if we claim a sling and the competitor doesn't actually have a sling, then they're not going to infringe this particular claim. We got a lot of pushback from our client on this one. Why don't you have the sling in this claim? I want to be able to protect the sling too. This is actually this is broader. It doesn't include that limitation. I want you to be able to start thinking like that. That's kind of the whole key to understanding patent law right there.
But yeah, it's like the second claim.
This one was not easy to get through the patent office. Again, there are a couple chairs in the world. Let me see if I could come up with a rejection here. Office action, there's a bunch of things pending. There's 2 claims that the patent office said should not be in this particular patent application, that they actually covered a slightly different invention. So the patent office was chopping this thing in 2 and forced us to withdraw those claims. We could pursue them later with the same filing date, but not in this patent application. And so all of the other claims that are still pending are now rejected. And this is the restriction and some objections. And then we'll get to something a lot more interesting in a second. Claims 1, 2, 5, 6, 14, 15, and 17, as best understood, are rejected as not being novel compared to this particular patent to Liebhold. Liebhold discloses a chair frame that has these, the features of the particular invention. And so the Patent Office went on to talk about why those claims are rejected, and then said that other claims were rejected as being obvious. And so those are two of the big requirements of a patent application, or the claims, that they're both novel and they're unobvious. We'll talk about those requirements in great detail 2 weeks from now. So this is what a patent, this is what an office action looks like. When we responded, this is what our response looks like. Examiner has rejected these claims. The applicant respectfully asserts that this reference does not teach these. In particular, the Liebhold reference does not teach or suggest we're in the second end of each of the end of the bar of the first pairs, and the second bar provide a sling interface. And so we were arguing that these particular references that the Patent Office had weren't actually disclosing these elements that we had in the claims. We don't often do this, but we did in this case because it was important. They were using the butterfly chair as an example of a chair that has 2 legs and it has a sling. The butterfly chair, of course, we've all seen this, has been knocked off even at Urban Outfitters. And so the examiner was trying to show that the butterfly chair was actually very similar to what our client was doing. And in a way it was, except for the butterfly chair has 4 legs and we have 2. And there's a couple of important differences there in how we actually brace for that. Went back and forth with the Patent Office several times. There's another amendment here, and another rejection here, and another rejection here, and another amendment, and it goes on and on and on. And eventually what we got was notice of allowance. As long as you pay the fee by this date, you're going to get a patent. And we did, and we got one. I just gave you like the 5-minute version of something that took about 4 years to do.
Like, oh, the Patent Office was right, there's nothing I can do there to go around what they're saying.
So it doesn't happen very often. I'd say maybe 5 or 10% of the time, where the Patent Office is just like, wow, yep, you got us. Like, there's no way around us saying it's exactly what we're doing. But typically, because we're filing so many different claims and dependent claims, we don't file a ton. Like, we're filed typically on the order of like 20 to 40. And there's some law firms that will file 200. But that's, in that 20 to 40, that's a lot there, and that's a lot of range. That might be something that's very broad and also might be something that's very narrow in there. And it's quite infrequent that we don't walk away with something, even if it's narrow. And sometimes our clients will say, well, this thing right here is too narrow, it's not worth it, let's abandon it. But I find that to be a very different situation than we're not going to get anything.
The Patent Office finds some prior art that for some reason you hadn't found.
Yeah, so there are 8 million patents out there,
Yeah,
which is a lot.
Yeah.
And then there's 1 trillion websites, which is a lot. And then there's another problem that we don't see the pending applications for the last 18 months. But they still beat us to the Patent Office. And so those things are still prior art. And so even if we spend all the time in the world searching, we still can't give any kind of guarantee to our clients that what we're doing is actually patentable. And yet another reason why we go in there with broad scope and narrow scope. This is effectively what I wanted to cover today. I wanted to give you some introduction of the Patent Office, the USPTO, public pair, that particular portal. I want you guys to be familiar with this. This is how you actually check the status of something. And then be able to play around. I would recommend jumping onto this relatively soon. It's not a particularly intuitive interface, but you should play around with it just to kind of get a feeling of what that's like. And this is effectively digging into the files at the Patent Office. They have now moved, I think, completely to an electronic version. Before, these files would be about this thick. And when you would go and you'd want to say, all right, I want to be able to look at one of those files, you would order it and it would come to you like 3 or 4 days later, and they would give this to you, and you'd have to go over to one of the copy machines that had 25 cents a copy, and you would actually make a copy of that, and $200 or $300 later, you would now actually have a copy of this thing. Of course, they use this really weird sized paper, and so you have this like very awkward thing that you would go back to the office with. Now we could just do it right here. And we just looked through and flipped through all the different papers, every single paper that was in this particular file that turned out to be an issued patent. If there are no other questions, I'll see you guys next week.
For more, please visit us at stanford.edu.